Enuanum Ghana from Amuina Akwaba at the Bank Casa TV and no first time Ocean Casa TV. Make sure say like no subscribe no share. Send every time be fresh news update I share. No who dia El Kosu or Oman Ghana. Ghana for Alban Badgin, already the Speaker of Parliament and in Samakuku Pimo quote you. As a was sent to honor the third in command, the whole Ghana. President Another Danko Fado and the first in command. If Fabana Dr. Mahamadou Bamian, or no Chimuson the third in command. To be able to me, now something in Anisawako and for sale law be a friend about the human rights, sexuality, and family bill, where law Alban Badgin our passe our parliament and some kitchen and hooky say and send SMP our Ghana have engusu enko story nim now Billy our wapasi Yera Godfred Yabua Daming Achechemu the entire bill it goes against every right, every code and every principle of the country. On its instant capacity bill will cry if it's number one, it goes against and I say it inputs charges on Ghana's consolidated funds or saying also it goes against Ghana's consolidated funds. And number two, it goes against Article 108 of the Constitution. Now I'm sure Sanya my name it wasn't tried say Alban Badgin never passes Sabi and I friends no also Sabi it's a very important bill I say a court another dan kweku fado anim no yam hu hwehwemu ansa na wa passes Sabi but Alban Badgin if in the right more passes Sabi there it is not something to be done. And I'm gonna mu ina mo kam na nkwaji sa ensem twemu mbra medamase
a repetition of those arguments. Save to develop just one point. The facts about the prohibition that I stated is implied in Article 108, the prohibition on Parliament from proceeding with a bill. I argued fully on that, but I'll develop the argument further by stating that that prohibition on Parliament from proceeding unless certain factors have been met actually implies a condition precedent to Parliament's power to act upon such a bill at all. I will state further that indeed that prohibition actually then operates as a fetter on Parliament's power from proceeding because it's a condition precedent. Without the satisfaction of that condition precedent, every step taken by Parliament is null, void, and of no effect. Especially if that is the case, the question arises whether indeed
there's even a bill.
There's a bill at all. Or there can even be a cure, a remedy for the default of the Speaker of Parliament in proceeding. Early on, my lady would observe that I actually made a point in answer to a question from the court that I would be hesitant in stating that the Speaker did not make such a determination, and I would rather say that there was lack of evidence of such a determination. Clearly now I've seen evidence of the omission. So I would have made my earlier submission to say that the Speaker actually omitted because there has been such clear concession by the first defendant in his case where he stated that the Speaker did not present such a determination at all. Already I will state that so clearly there was nothing, no basis on which Parliament could proceed because there was a failure to satisfy the very important condition precedent of the Speaker or the person presiding, presenting an analysis of the impact on the consolidated fund. I would further submit that such an omission cannot be cured by the President's election to refer the bill back to Parliament for reconsideration. Indeed, what if the President does not refer the bill back to Parliament? It means the nation lives with their own constitutionality. That would clearly be the implication. If the President decides not to present the bill back to Parliament, the nation will live with such unconstitutionality. And that will be a huge scar on the constitutional landscape of the nation. I submit that there's again no independent power of Parliament to reconsider a bill after the processes in Article 106 of the Constitution have been satisfied, which indeed have been up to this stage. Parliament has fully exhausted all the processes of considering a bill. The bill has been introduced in Parliament, has been read for the first time as required under Article 106, Clause 4 of the Constitution. It has been referred to the appropriate committee of Parliament under the same Article 104, Clause 4 of the Constitution. There has been a deliberation. There has been a deliberation upon the bill by the appropriate committee as required by Article 106, Clause 5. Indeed, the bill has been read for the second time. It's been subjected to full debate as required by Article 106, Clause 6. And indeed, it has been read for the third time. It has been passed by Parliament. Especially, my submission is that upon the satisfaction of all these steps required under Article 106, there is no room for Parliament on its own to reconsider such a bill. And therefore, there is no provision for a remedy or a cure of a failure to comply with Article 108, paragraph A of the Constitution.
Honorable Attorney General.
Yes, especially.
Did I hear you say that after a bill has been assented to and it's become an act, that there's no other opportunity to take the matter on?
No, it's definitely not.
I didn't.
No, it's
I didn't
not.
hear you right.
No, it's
I am glad.
The point, yes, definitely. The point I made is
even on closure at the bill stage, Parliament's rights are exhausted, or Parliament's capacity, authority is exhausted.
Yes, that
cannot receive the bill
on its own.
On its own.
Yes, that at the stage we are, Parliament's power to independently review the bill or provide a remedy or cure, as earlier on advocated by my learned friend, does not exist.
No. What your learned friend is saying, which I think is compatible with what you're saying, is that it is the president who can tell them that there is this defect, and so cure it.
Right.
Yes.
And then he also
and Mr. Abedu says that supposing the president doesn't do that, the nation will have to live with an unconstitutionality.
Precisely. And that's the point I make, that indeed, so it is up to the president to do that. And I respectfully made the point that at this stage, Parliament cannot independently do anything at all. And if the president also does not elect to refer the bill to Parliament or even to Council of State, then the nation lives with their unconstitutionality. And I made the earlier point that it will be incongruous for Parliament or the nation to be, for such a bill to be foisted on the nation purely on account of an omission of the Speaker of Parliament to undertake an act which is required by Article 108, Clause 8, which is make a determination, which clearly is not in doubt at this stage.
Honorable Attorney General, do I understand you to be saying that if you, as legal advisor of the government, if you offer an opinion on something, the government won't listen, the president won't listen, and will sign anyway, even if you tell him, no, don't sign this one?
Respectfully, no. You see, that's the point I make. That is why I preceded my arguments in the other matter with on the basis that indeed I made all these submissions, not to assist the court to determine a case. It is to settle a question. And the question I respectfully want the court to settle is whether indeed a bill passed in flagrant violation of Article 108, Clause A, which enjoins the person presiding to make a determination, is valid or not. But the issue for me goes beyond the substance of this bill. So indeed, we must look at, with all respect, the bigger picture. That now private members bill has come to deal with us. Every day,